attorney with the domestic unit at Legal Aid of Western Missouri. If you have been granted visitation or custody by court order and the other parent is denying you any visitation or custody rights that you were granted, you have an option to file what is known as a family access motion. I'm here to tell you about the family access motion and how you go about filing those forms with the court. The first thing you need to know is when to file a family access motion. Family access motions are authorized by Missouri law, which allows a person to file this motion if his or her rights to custody or visitation are being interfered with by the other parent without good cause. Often, people mistakenly believe that an order of protection may be the appropriate form to file in this case. However, unless physical abuse and denial of custody or visitation rights is being alleged, most likely a family access motion is more appropriate. A full order of protection is meant to protect victims of abuse, not restore custody or visitation rights. To file a family access motion, find a copy of the most recent custody order, which will be found in either your divorce decree or the custody or paternity order. Take that copy with you to the circuit clerk's office of the county where the custody order originated. The addresses of the circuit clerks can be found at www.courts.mo.gov. Ask the circuit clerk for a family access motion form. This form can be found at www.selfrepresent.mo.gov. The clerk should assist you in completing this form. When completing the form, start with the caption. This is the part at the top of the form. Caption the form exactly as your custody order appears. You'll start with the very first line. The caption are the words that appear at the top of most legal documents. For example, if your case was filed in Jackson County, Missouri, you would type in the 16th Judicial Circuit Court, Jackson County, Missouri. Put in the judge or division that your case was filed in and the case number exactly as it appears on the form that you were given. If it was an 09 case, it will probably look something like 0916-FC and then fill in the rest of the numbers. Type in the names of the parties exactly as they appear on the form. If you were the respondent in the original action, you would continue to be the respondent here, even if you were the one filing the family access motion. Type in the full parties' names and the social security numbers and the addresses. Typing in the addresses as accurately as you know them is very important because you will have to serve this document on the opposing party, and the sheriff will have to find that person at that address to be able to serve them. The clerk will enter the date file stamp, so leave that part blank. In the body of the order, check all of the boxes that apply to your situation. Everyone should check the first box, that a judgment or dissolution or legal separation was entered in blank county, Missouri. And again, type in the county that your original order originated from. Check this box and fill in the blank even if it was simply a custody order and not a judgment of dissolution. Just scratch out dissolution and put custody there. If that original judgment has been modified by another court or order, check the second box and fill in the blank. This will not apply to everyone. In the third blank, write the name of the person denying you visitation. This name should be either the petitioner or the respondent listed in the caption. If someone other than a party to the original custody action is denying you custody rights, a family access motion is not appropriate. You should contact the police to enforce your custody order or an attorney if the police are unable to assist you. In the space provided under the third blank, this big box here, list in detail all the ways that you have been denied custody or the other parent has interfered with your custody rights. I recommend finding the parenting plan contained in your custody order and going paragraph by paragraph, listing in detail the provisions that are being violated and how they are being violated. Denial of custody includes situations like denial of phone contact and failure to provide information regarding the children, if provided for in the custody order. It is very important that you list each way in which your rights are being denied. If you do not list it in the motion, you will not be able to bring up the issue in mediation or in court. After you list each way in which the order is being violated, check each box that corresponds to the request that you are making. Remedies in a family access motion include those listed on the motion. For example, you may request to be provided a period of visitation equal to that of the time that you have been denied, to participate in counseling with the other party, to have the other party pay a fine of up to $500, or have the other party pay your reasonable expenses in bringing the family access motion. Again, it is very important that you check each box that describes the relief that you want. If you do not request it, the court or mediator cannot grant it. Once you have fully completed the front page, do not forget to sign and date the form on the second page. Be sure to include your address and phone number. Give the completed, signed form to the circuit clerk for filing. You will be charged a filing fee, which varies depending upon the county in which you are filing. The fee in Clay County is $132, Jackson County is $180, and Platte County is $100. If you cannot afford the fee, you may file a motion and affidavit in support of request to proceed as a poor person, which, if approved by the court, will waive the filing fee. This form is also available at www.selfrepresent.mo.gov. Within 5 days of filing this form, the court will issue a summons to be personally served on the other party. Service may be done by the sheriff or a private process server. If you proceed with a private process server, that person must be approved by the court. The court clerk will have a form to appoint a private process server. There is a fee for the sheriff to serve the family access motion, which may or may not be included in the filing fee. It is very important that you provide all information you have regarding the whereabouts of the other party, including home and work addresses, so that service can occur. The court cannot proceed with your family access motion until the opposing party is served. If the family access motion sits too long and service does not happen, it may be dismissed by the court. Once the other party is served, the court will likely schedule an alternative dispute resolution session within 14 days. Alternative dispute resolution, or mediation, is a process where a neutral third party sits down with both parents and attempts to reach a mutually agreeable resolution to the problem. Mediation sessions generally last 1 to 2 hours, but time will vary depending on the issues of the case. You will be charged an hourly fee for mediation. When the mediation or arbitration is scheduled, gather all evidence you have of the denial of visitation and your attempts to have visitation or contact with your children. Bring all evidence that you have to the mediation session. The mediator will allow each party to tell his or her side of the story. As difficult as it may be, it is really important to remain calm in the mediation session and be respectful to everyone involved. The goal of the mediation session is to reach a resolution to the problem. Anger and resentment will not help in accomplishing this goal. After the mediation session, the mediator will draft his or her proposal for resolution with regard to denial of visitation. This proposal will include all suggested actions, including make-up visitation, fines, and an award of costs or fees, if any. If you disagree with the mediator's proposal, you should have the option to appeal it to the circuit court judge. Instructions for disagreement should be included in the mediator's proposal. Hopefully, the result of the family access motion is continued contact with your children. A family access motion will not modify a custody order that is already in place. If that is your desire, you should contact an attorney regarding a motion to modify custody. Thank you.